Hello everyone, I would like to welcome you to this latest lecture on extradition, deportation and asylum as a part of the Swayam course on international law. The principle of extradition in international law refers to the legal process by which one state, that is the requested state, surrenders an individual to another state, that is requesting state, for prosecution or to serve a sentence for a crime that has been committed. Extradition is based on agreements between states and aims to prevent individuals from evading justice by fleeing to a foreign country. Extradition is crucial for addressing cross-border criminal activity and ensuring that individuals do not escape accountability by moving to another jurisdiction. Extradition is typically governed by bilateral or multilateral treaties between states. These treaties define the conditions under which extradition is granted and specify the types of crimes for which extradition may be requested. Extradition treaties outlines essential elements such as the list of extraditable offences, the required legal documentation and the procedures for making request. Many countries sign multilateral treaties like the European Convention on Extradition of 1957 or the Inter-American Convention on Extradition of 1981, which facilitate cooperation between countries in the same region. Extradition is typically not granted unless certain conditions such as linkage to extraditable offences, dual criminality, absence of political offences, no death penalty and no risk of torture or inhuman treatment are met. Dual criminality is a fundamental principle in international extradition law, which requires that the act for which extradition is requested must be a crime in both the requesting state and the requested state. In other words, an individual can only be extradited if the alleged offence is recognized as a criminal act in both the country seeking the extradition and the country being asked to surrender the individual. Under the principle of dual criminality, the offence for which extradition is requested must be illegal in the jurisdiction of both the requesting state where the extradition is sought and the requested state where the individual is located. For example, if an individual is accused of committing an act that is a crime in the requesting state, but not in the requested state, the requested state will likely refuse the extradition request. The principle of dual criminality does not require the crime to be defined in exactly the same way in both states. The key is that acts committed must be substantially similar and constitute a crime in both jurisdictions, even if the legal definitions or classifications differ slightly. The principle typically applies to serious crimes like murder, fraud, drug trafficking or theft. If a crime is considered serious in both jurisdictions, it is more likely that dual criminality will be satisfied. If the alleged offence is not recognized as a crime in one of the states, for example, an action that is legal in the requested state, but illegal in the requesting state, extradition will generally not be granted. The principle of dual criminality ensures that individuals are not extradited for acts that are not criminal under the laws of the requested state, protecting them from being punished for something that may not be considered a crime in their country. It also helps prevent the misuse of extradition treaties for political purposes or to target individuals for actions that are legal in the requested country. The principle respects the legal sovereignty of states, ensuring that one country cannot impose its own laws on another country by using extradition to punish conduct that is not criminal in the requested state. A second principle which may be in force in certain countries is a ban on extraditing citizens, which refers to a legal or policy restriction that prevents a country from surrendering its own nationals or citizens to another country for prosecution or punishment, even if they are accused of committing serious crimes abroad. This principle is often rooted in national sovereignty and the belief that a state should maintain control over its citizens and protect their rights under its legal system. The primary rationale for the ban is to preserve sovereignty. Countries argue that they should have the right to prosecute their own nationals under their legal system, especially for crimes committed abroad. Surrendering a citizen to a foreign country for prosecution may be seen as an infringement on the state's control over its citizens. Many countries are also concerned that their citizens could be subjected to unfair trials, inhuman treatment or the death penalty in the requesting state. For instance, some states may refuse extradition to countries where the individual may face torture, discrimination or an unfair judicial process. In countries with a ban on extraditing nationals, the state may often offer an alternative such as prosecuting the citizen domestically for the same crime. This is known as the principle of od dedere or judicare, meaning either extradite or prosecute. The country may also agree to transfer the individual to the requesting state if they are willing to serve their sentence domestically after conviction. To provide a pathway against the absolute ban on extraditing citizens, some extradition treaties include specific provisions for citizens. For example, a country may agree to extradite nationals if they are guaranteed a fair trial or protection from the death penalty. In the European Union, the European arrest warrant allows member states to extradite their nationals for prosecution or to serve a sentence in another EU member state, eliminating the national ban on extradition within the EU. Even in countries that do not extradite their nationals, the principle of od dedere or judicare may apply. This principle means that if a country refuses to extradite its citizen, it must prosecute the individual for the crime under its own laws. For example, if an individual commits a crime abroad but returns to their home country, that country may choose to prosecute them domestically rather than extradite them. There are also other situations when extradition requests may be denied. For example, many countries exclude political crimes from the list of extraditable offences. This is done to protect individuals who may face persecution for engaging in political dissent, such as protesting government actions or opposing regimes. The definition of what constitutes a political offence can be highly subjective. What one state views as a legitimate political act, example, speaking out against the government, may be considered a crime in another state. This raises concerns that governments could use extradition to target political opponents or activists. Some countries also refuse to extradite individuals to countries where the death penalty could be imposed for the alleged crime. The request for assurances that the death penalty will not be imposed is a key point of contention in extradition cases. Countries like the European Union and Canada have strong opposition to the death penalty, and they may refuse extradition to countries where the accused could face capital punishment. Another key controversy which is present involves concerns that extradited individuals may face torture, inhuman or degrading treatment or unfair trials in the requesting state. International human rights laws such as the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment of 1984 prohibit the extradition of individuals to states where they are likely to face torture or other ill treatment. However, proving that extradition would result in such treatment is often difficult, leading to potential diplomatic tensions. Lastly, states may refuse to extradite individuals if they believe the requesting state would not provide the accused with a fair trial, or if they fear the individual would face the death penalty, torture or inhuman treatment upon extradition. For example, in the case of Julian Assange, the founder of WikiLeaks, the United States requested his extradition on charges related to espionage. However, his extradition was contested by several parties due to concerns about the mental health and the risk he could face inhuman treatment or a lengthy prison sentence in the United States. Moving ahead, now let us look into the principle of deportation, which in international law refers to the removal or expulsion of a person from another country, typically against their will, because they are considered to be illegally present, have violated immigration laws or pose a threat to national security. Deportation is a process through which a state forces an individual to leave its territory and return to their country of origin or another country willing to accept them. This action is distinct from extradition, which involves the surrender of individuals to another state for criminal prosecution. Deportation can sometimes intersect with extradition if an individual is deported to face criminal charges in their home country or another state. However, deportation is typically an administrative act rather than a judicial process like extradition. Deportation can occur for various reasons, and while it is primarily governed by national laws, international law provides certain protections to ensure that deportation does not violate human rights or lead to unfair treatment. Deportation typically occurs when a foreign national is found to have violated immigration laws or when they are found to be living in a country without legal authorization, for example, overstaying a visa or entering without permission. Other common grounds for deportation include criminal activity, national security concerns, or if the individual is deemed to be a threat to public order. A country may deport undocumented migrants, that is, individuals who have entered the country without proper authorization or those who have overstayed their visa. The country of origin or another state may be responsible for accepting the individual back. However, if the migrant faces significant risks, example persecution, the deporting state may be prevented from carrying out the deportation under the principle of non-refoulement. Lastly, a person who has been convicted of a crime and is serving a sentence may be deported upon completion of their sentence. However, the deporting country must ensure that individual will not face inhuman treatment or unfair trial procedures upon their return to their home country. The process of deportation may be controversial. International law, particularly human rights law, provides protection against deportation in certain circumstances to ensure that individuals are not subjected to inhuman treatment or torture. The 1951 Refugees Convention and the 1967 Protocol relating to the status of refugees prohibit deportation of refugees to a country where they would face persecution. This is a significant protection, ensuring that refugees are not sent back to a country where their life or freedom would be at risk due to factors such as race, religion, nationality or political opinion. The principle which prevents forced return or expulsion of a person to a country where they may face persecution, torture or other serious harm is called refoulement in international law. This principle is particularly important in the context of refugee law and is enshrined in several international treaties to protect individuals seeking asylum or refuge. The non-refoulement principle primarily protects refugees and asylum seekers, individuals who have fled their country of origin due to a well-founded fear of persecution. It also protects people from being deported to countries where they may be at risk of torture or inhumane punishment, even if they are not officially recognized as refugees. While non-refoulement is a widely accepted principle, there are limited exceptions under international law. For example, a state may be allowed to expel or return an individual if they are a threat to national security or have committed serious non-political crimes or are considered a danger to the community of the country to which they are seeking refuge. These exceptions are narrow and are meant to ensure that the principle of non-refoulement does not become a shield for criminals or individuals posing a threat to public safety. Non-refoulement is a binding obligation on states that have ratified the relevant international treaties. However, the enforcement of this principle can be complex, particularly when countries do not cooperate on asylum cases or have insufficient safeguards in place. International bodies such as the UN High Commissioner for Refugees play a key role in advocating for the protection of refugees and ensuring that states comply with non-refoulement obligations. The principle of non-refoulement is frequently applied for asylum seekers. A person fleeing political persecution in their home country applies for asylum in a foreign country. If that country decides to deport the asylum seeker back to the country where they fear persecution, example, they might be jailed, tortured or killed. This would constitute refoulement. Now, moving ahead, asylum in international law refers to the protection granted by a country to individuals who have fled their own country due to a well-founded fear of persecution. Asylum provides individuals with the right to remain in a host country and protects them from being sent back to their country of origin, a practice known as refoulement, if they face danger upon return. The right to seek asylum is a fundamental human right and is a core principle of international refugee law. The right to seek asylum is primarily enshrined in the 1951 Refugee Convention and its 1967 Protocol. These documents provide the legal definition of a refugee and outline the obligations of states to protect refugees. Article 14 of the Universal Declaration of Human Rights states that everyone has the right to seek and enjoy asylum in other countries if they face persecution in their home country. The Refugee Convention of 1951 also specifically outlines the criteria for granting asylum to individuals who meet the definition of a refugee. According to the 1951 Refugee Convention, Article 14(2), a refugee is someone who is outside their country of nationality or habitual residence and has a well-founded fear of persecution because of their race, nationality, religion, membership in a particular social group or political opinion, or is unable or unwilling to return to their country due to this fear. Asylum is granted to individuals who qualify as refugees under the definition, and the host country must protect them from being sent back to a country where they would face such persecution. Asylum procedures vary by country, but they typically involve an interview or hearing to determine if the asylum seeker qualifies for the refugee status. If granted asylum, the individual receives legal status, protection and potentially other benefits such as the right to work, education or family reunification. If an asylum claim is denied, the applicant typically has the right to appeal the decision in a national court or tribunal before facing deportation. In some cases, countries provide temporary protection to individuals who cannot return to their home countries due to their ongoing conflict, violence or disasters. This protection is often temporary and allows individuals to stay in the host country while the situation in their country of origin remains unsafe. Asylum is distinct from regular immigration. While immigrants typically move to another country for economic opportunities, family reunification or other reasons, asylum seekers are fleeing life-threatening situations such as war, oppression or violence. States may have specific immigration procedures and laws for admitting economic migrants, which are different from the processes used for granting asylum to individuals fleeing persecution. India does not have a comprehensive national asylum law like many other countries, but its policy on asylum is shaped by a combination of international commitments, constitutional provisions and domestic laws. India's approach to asylum seekers and refugees is primarily based on humanitarian considerations with specific protections afforded to certain groups. While India has not signed the 1951 Refugee Convention or its 1967 Protocol, which are key instruments of international refugee law, it has nonetheless provided asylum to various groups and individuals over the years. India has historically provided asylum on humanitarian grounds, often to people fleeing conflict, political persecution, or ethnic violence. For example, Tibetan refugees, Sri Lankan Tamils, and Afghan refugees. Over the years, India has also hosted Afghan refugees, particularly in the wake of the ongoing conflict in Afghanistan. To summarize, deportation in international law refers to the act of forcibly removing a person from a country, typically due to violations of immigration laws, and returning them to their country of origin or another willing country. While countries have the right to deport individuals, international law offers protections, particularly for vulnerable groups such as refugees or those at risk of torture or persecution. Human rights law such as non-refoulement, which limits the scope of deportation to ensure that individuals are not sent to situations that would violate their basic rights. With that, we wind up the discussion on extradition, deportation, and asylum. We look forward to meet you in the future lectures.